All right. Hi, everyone. My name is Jason Q. I'm a managing attorney with the DC Bar Pro Bono Center in our nonprofit and small business legal assistance programs. Thank you for joining us today for our webinar, part of our Board Basics training series. And we're going to go high level today. We're going to talk about the legal and operational director's responsibilities of a nonprofit board of directors. Before we get started, just want to get into some housekeeping and some logistics. So we are doing this webinar on the GoToWebinar platform. You have the ability to ask questions during the presentation. If you just pull down the questions tab of your GoToWebinar client, for those of us joining live, you can put in your questions, type them in. That's the only way to communicate with us during the webinar, but I will be keeping an eye on the questions throughout the presentation, and we'll hopefully be able to get to as many as we can. We have a lot of content to cover today, but I'll try to hit up definitely the most relevant questions as we're going through the presentation. If there are any questions that we can't hit up in the live time that we have together, my contact information will be on the last slide. You can reach out and we can communicate offline about any of your remaining questions. I have a question in the field already. Will the PowerPoint slides be available after the webinar concludes? Yes, the PowerPoint slides for those of us joining live are available already. If you pull down the handouts tab of your GoToWebinar client, you can download a PDF version of the slides right away. And yes, this presentation will be archived on our resource website that I will point you to in a moment. All right, so a few more housekeeping bits. Let me tell you a little bit more about our organization. We are the DC Bar Pro Bono Center, and we have a nonprofit legal assistance program. That program has a lot of different features. We have a match program that can match you with pro bono legal counsel. We host in-person and virtual legal clinics to address issues like governance policies, risk management, intellectual property, a lot of issue-specific legal clinics, opportunities for you to get brief advice from attorneys. We sponsor trainings, webinars, multi-session training courses, and podcasts on important real-world legal issues facing nonprofits. And we have a written resource and training archive on our website. That's lawhelp.org/dc.npsb. And especially for a presentation like today's presentation that's super high level, we're going to be issue spotting and identifying a lot of different issues. But if you want to take a deep dive into anything that we talk about today, that Law Help website is going to be where you want to go. And I will try to remember to flag where we have additional Law Help resources as we're going through the presentation today. All right, let me turn my camera off so I have a bit more screen time or screen space for me. Here's just a really big high-level outline of what we're going to talk today. We're going to talk about the legal background of the board of directors for your nonprofit, and then we're going to dive into the 4 fiduciary duties that we recognize here in DC. These are legally recognized and enforceable duties that you as a nonprofit director are responsible for understanding and for executing. The meat of the presentation is really duties 1 and 2, the duty of care and the duty of loyalty. I think we'll spend 90% of our substantive time talking about those duties, but we'll touch briefly on the duty of obedience and the duty to inform as well. So let's do that legal background. Let's talk about why we're in this space and why these duties exist. So the nonprofit corporation, your nonprofit organization, it's its own legal entity. It's incorporated and it's authorized to carry out the charitable mission of your organization. Most of the folks here today and most of the folks listening to the presentation are going to be 501c3 nonprofits. These are tax exempt and tax advantaged corporate entities that essentially receive a subsidy from the public in the form of tax deductions for donors and tax exemptions for the organization itself. So you don't pay tax at the corporate level, like income tax or franchise tax, other sorts of taxes that most businesses pay. Excuse me, especially in the C3 space, donors to your nonprofit can also deduct the value of those donations if they itemize their deductions. But as sort of, to balance that out, or sort of the price of those tax advantages, is that you're subject to additional oversight and reporting. And a big part of that oversight piece is the board of directors. Nonprofits are required to have a board of directors that's responsible for the management of the organization and for ensuring that your organization is run in the public interest. Now, this is not something that we'll focus on in this presentation, but some nonprofit corporations may also have voting and governance empowered members. I call these capital M members. These are folks who act similar to shareholders in a for-profit corporation. They have the right to elect the board and they have the right to approve major corporate transactions. Most nonprofits do not have these kinds of capital M members. Instead, you might have folks that you call members who, pay dues and get benefits, but you're going to have to look to your articles of incorporation and your bylaws to see if you have those capital M governance level members. Again, most of you do not. But if you do, they're another stakeholder and another decision maker, the membership body in your organization. Today, we're really going to be focused on the board, since again, most of you are going to be led and governed by the board of directors only. All right, the board of directors, who's it accountable to? You're accountable to a lot of folks. As sort of the trustees of the organization, you're in charge of making sure it's operated in the public interest. So at a very high level, you are accountable to the public. We're going to talk about this a bit more, but the regulators and government overseers of nonprofits, like the Attorney General and the IRS, you're definitely accountable to. If you have those capital M members, you're accountable there as well. Your decisions are also going to have ramifications for your donors, your clients, your beneficiaries, and then internally your employees and your volunteers. So when we talk about governance and we talk about oversight, there's a lot of players at the table. And so this is some of the folks that we're thinking about. And something that, we need to emphasize, but maybe we'll lose sight of as we get into the real nitty-gritty of what these fiduciary duties are, is that an important role of the board is setting the tone for the organization and setting a culture of compliance. Staff and volunteers take their cue according to the ethical climate established by the board. So we want to make sure that our directors, outside of just these being like legal duties that we care about, we also want the directors to adhere to and set a high ethical standard so that it flows down through the organization and you avoid legal risks or problems in the future. And of course, the board is responsible for ensuring that the organization complies with applicable local, state, and federal laws. That is actually the core of the duty of obedience, our third duty. So we will return to that topic shortly. Okay, a few more basics about the board. Let's talk about the number of directors on your board. So legally in DC and in most other jurisdictions, you have to have at least 3 directors. There's no legal maximum to the number of directors. So that's probably going to be governed by what's in your bylaws. But, as you're thinking through what your ideal board size is, think about operational considerations like, can we meet our quorums to have meetings and to make decisions? And as we talk about things like the duty of care, which essentially requires that your directors be present and be engaged and be informed, if your board is too big and you're not meeting often and it's hard to keep track of everyone, it's hard to get everyone committed and engaged, that can be challenging in terms of satisfying an individual director's fiduciary duties to the organization. It's easy for them to get disengaged. It's easy for them to miss important information. So one background consideration when we're thinking about board size is we're trying to get that sweet spot where we have enough people to do the work of the board, to generate resources, but we don't have too many people that folks aren't really digging in and performing that legal duty to oversee the organization and to make decisions with due care. Another concept that you'll hear about is the idea of independent directors. These are directors that are financially independent from the board and from the organization, so they don't have financial transactions with the organization, and their family members also don't have financial relationships or financial transactions with the organization. That can include being a staff member of the organization or drawing any other kinds of salary. That can include being a contractor or a vendor with the organization. So it's okay for some of your directors to have those financial relationships. We can navigate those through our conflict of interest process. But on the whole, your board should be made up of independent directors who do not have those family or business ties to the organization. They're really just serving the organization from a slightly more objective and unconflicted posture. Our goal should be that a substantial majority, let's say around 2/3 at least, of our board is made up of independent directors. Another issue we should think about is our terms of office. By default, it's a 1-year term under the DC Nonprofit Code, unless another generally longer term is specified in your bylaws. In the code, the maximum length of a single term is 5 years, but folks can be re-elected to additional terms. I'm going to talk a lot about DC law in this presentation. I think I probably should have mentioned this earlier. We are a DC legal services organization. So I'm going to be talking to the extent that state law is relevant about DC law. If you're not a DC incorporated organization, the legal requirements that apply to you might be different. So when I mention DC legal requirements, take that as a cue to check what your state requires from your nonprofit. Okay. Your board must have regular elections as stipulated in your articles and bylaws. And again, you cannot generally hold over on the board past your term unless you're re-elected in accordance with your articles and your bylaws. Okay, so that's setting the stage. Now, we're talking about boards, but I do want to mention officers. Officers are, aside from the directors, maybe the other key set of leaders in the organization. Officers are folks with a specialized leadership role in the organization. Instead of just sitting on the board and voting as a body, they have unique leadership responsibilities. So under DC law, nonprofits must at least have a chief management officer. That's usually the board chair or the board president in a lot of organizations, and a chief financial officer, which is often the treasurer in most organizations. Someone else, usually a secretary, must also be in charge of keeping the books and records of the organization. So the president / chair, the treasurer, and the secretary are the 3 officer positions that are required generally under DC law. Other individuals can, but need not be employees. Officers can, but need not be employees of the organization, especially in younger organizations. Directors on the board are simultaneously performing one of these officer roles. So you can have a board of, let's say, 7 people. Of those 7 folks on the board, 3 or more of them might simultaneously be performing one of these officer positions at the same time. Again, that's chair, president, treasurer, secretary. Some folks also have vice presidents and other positions. In more mature organizations, that chief management officer role often transitions from the board chair or president to your executive director or your CEO. So that's another dynamic that you might see, especially for folks who have a paid executive director. That CMO officer title shifts to that individual, and the president or chair can focus more on leading the board instead of leading the organization as a whole. Again, the terms of your officers and your responsibilities are set out in your bylaws. For the purposes of today's presentation, I just wanted to have this slide because folks are often confused between what officers are and what directors are. We're going to focus on directors, but something to keep in the background is that a lot of these fiduciary duties often apply similarly or identically to officers as well. Okay, that's sort of setting our stage. We're going to dive into the 4 key fiduciary duties that we recognize here in DC and in many / most other jurisdictions. These are, again, legally recognized and enforceable duties, and they come from a number of legal authorities. So here in DC, we have our Nonprofit Corporation Code. This is a statute. It's a written code of law that sets a lot of norms and expectations and requirements around running a nonprofit, including the conduct of board meetings, including your fiduciary standards, and including issues around director liability. So the DC Nonprofit Code and other state nonprofit codes are the font of a lot of these legal requirements. But especially in the world of fiduciary duties, common law is really relevant. So the scope and definition of fiduciary duties, like the duty of care or duty of loyalty, have developed through a history of court opinions, stretching all the way back to the beginning of our legal system, interpreting common law concepts around what a director of a nonprofit is responsible for. And these court opinions are still relevant for understanding the scope of fiduciary duties, especially within a particular jurisdiction, because courts in a certain state or jurisdiction can interpret these requirements a little bit differently. So they're codified in our nonprofit codes, but there's also this background of court-made common law that helps us define some of these issues. And then at the federal government level, the Internal Revenue Service and the Internal Revenue Code has a lot of relevant requirements, because as a condition for receiving your 501c3 status, your organization opts into complying with the provisions of the Internal Revenue Code. And there are provisions around governance and reporting and transparency and conflicts of interest, especially, that are relevant or that overlap with concepts around fiduciary duties. Okay, I have a kind of good audience question here, going back to something we talked about a second ago. If a chief management officer transitions to the executive director / CEO, wouldn't they be less involved in the board versus more? So yeah, if your chief management officer is the chair of the board or the president, and then you hire an executive director or CEO for the first time, and then they become the chief management officer, that means that a lot of those management duties can transfer to your executive director or CEO. These are like the day-to-day operational sort of management functions of the organization. What's left for the chair or the president of the board is really more of a governing or strategic role. In terms of overseeing the board itself, in terms of managing the board, and then those board level duties around setting strategic priorities, etc. That is going to be the core of what your president or chair is doing. So, but in my mind, that means that they're more involved or more focused on just the board itself. Instead of also, especially with those younger working boards, your chair or your president is often also focused on those day-to-day management functions. And this really depends on where your organization is in its growth and maturity. Okay, who oversees things like the nonprofit code and those other requirements we talked about? So the IRS at the federal level has the authority to audit and investigate nonprofits to ensure that they're complying with the Internal Revenue Code. If there is non-compliance, you can lose your tax-exempt status, and in some cases, there can also be penalty taxes, and we'll talk about this on directors who misuse a nonprofit's assets for personal benefit. Locally, the DC Office of the Attorney General is the key regulator here in the district. It has the authority to ensure that your directors are operating the nonprofit for the public benefit and in compliance with the law. And it's also possible for fellow directors or other key stakeholders to attempt to enforce fiduciary duties through the courts. So you're going to get enforcement coming from potentially a number of different directions. Now that we've understood sort of how the stage is set, okay, I can finally get into our 4 specific fiduciary duties. Let's start with the duty of care. The duty of care is our quality control duty. It speaks to the level of care and diligence that you as a director on the board need to exercise while performing this function. In DC, to satisfy your duty of care, a nonprofit director must act in good faith, in the best interests of the organization, and as a reasonable, prudent person would act under similar circumstances. So when you're making decisions on behalf of the organization, this is sort of the standard that you're accountable to in making those decisions and in performing those functions. I want to break that down into some kind of more digestible nuggets to think about. So this means being informed and using common sense and being diligent in exercising your duties as a board member. It means attending board and committee meetings and reading the materials and reports that come out of those meetings. It means engaging in open debate and necessary inquiry. And it means reviewing financial records and understanding the financial situation of your organization. So what folks might be gleaning here is that the duty of care does not mean that you need to be perfect. It doesn't mean that you always need to make the right decision. It doesn't mean that you have to be an expert in all things nonprofit including nonprofit finance and risk management and all these technical areas. But it does mean that you have to have a high level of awareness around these issues and look at how much we're focused on education, information flows, and staying on top of these various areas. And so I'm going to break down again some of these specific areas of concern in the next couple of slides. But before we get into that, I want to give you an example of like the most extreme end of the spectrum when it comes to a nonprofit director not being present and not exercising their duty of care. So this was a big story that hit in March of 2022. A nonprofit system around Minneapolis being investigated by the FBI for massive fraud in a food program. This group of nonprofits overseen by Feeding Our Future received more than $65 million to feed hungry kids during the pandemic. But the FBI is alleging that almost none of that money was actually used to feed the kids. Instead, the money was misappropriated, and then taxpayers were charged for non-existent meals. So one of the spicier, more intense nonprofit fraud cases we've seen in recent history. And when it comes to the board, Feeding Our Future had a 3-member board, but the man listed as the president said that he had been tricked into taking the job and had absolutely nothing to do with overseeing the organization. He said that a friend just asked him to put his name on some piece of paper. He did it, and suddenly he was president of the board. So this is what happens when you are completely absent. I don't think that's going to be the situation in any of our organizations, but we are going to be thinking about what level of diligence, what level of attention we should be exercising when we're on a nonprofit board. Okay, let's break down some components of the duty of care. First, we're going to talk about that information gathering function, but also delegation. So especially on those younger working boards, a lot of directors are working on the ground. You know, they're setting up programs, they're running events, they're doing a lot of the work on the board. So they have firsthand experience. But more typically, and as boards get more mature, those directors are sitting back a little bit from management, sitting into more of a governing and strategic role. And those functions are being delegated to staff, to outside experts, and then to committees exercising within their subject area. So as the board becomes more and more removed from the day-to-day operations of the organization, we need to think about how that intersects with your duty of care. And ultimately, it doesn't abdicate your duty of care that you've set back and taken a more strategic and observational and governance-minded role. It just means that that duty looks a little bit different. You still have ultimate responsibility for overseeing and managing the organization, but that means that you're going to rely more on systems of information flow and reporting so that you remain informed of critical work and internal developments at your organization. That means that as a director, you should be independently evaluating the position taken by other board members, by staff, by committees, by consultants, and asking for clarification and additional information if necessary. You can't just rubber stamp everything that your executive director tells you. That's not your job. Your job is to ask those prickly questions, ask for more information if need be. Also, directors can't ignore red flags indicating that delegated bodies are not performing effectively or reliably. If a lot of your financial management and oversight, for example, is being delegated to your finance committee, but you know that your finance committee isn't meeting regularly, you know that folks are not super engaged, the reports that it's creating are leaving a lot of holes, you can't just put your head in the sand and say, oh, I'm sure everything's fine. If your delegation of authority, if there's any reason to question that who you've given those functions and responsibilities to, you need to re-engage with those responsibilities and take that accountability back. A critical sort of tool in exercising your oversight responsibilities is the board meeting. Under DC law, the board may only act at a duly called board meeting where proper notice has been given and a quorum is present. So we still think of the board procedurally as mostly acting in the context of a board meeting. As we've learned during the pandemic, A board member can participate at a board meeting and be present via electronic communication, so like web or conference call, provided the director can hear the other directors, they can speak, and they can vote. So e-meetings are fine. They still satisfy these meeting requirements. What a board member cannot do is vote remotely by ballot. So this means that they don't actually show up to the meeting, but later on they're emailed an e-ballot to vote yes or no on something that was discussed during the meeting. You can't do that. And proxy voting is also not allowed. So proxy voting is, I can't come to the meeting, but I ask my friend who's on the board to vote yes to something on the agenda because I know that I'm going to support that proposition. And that makes sense if we step back and think about this whole idea of the duty of care. You can't cast an informed vote if you're not present for the debate and information sharing that occurs at the meeting, right? So the vast majority of our actions by default are going to be happening within the confines of a duly called board meeting where proper notice has been given and quorum is present. There's one big and useful exception to that rule that we recognize here in DC and in a lot of other jurisdictions, and that is the unanimous written consent provision. So under this provision, an action can be taken by the board without a meeting if it's clearly spelled out in writing. So usually you would create some sort of resolution or other written proposal. And then all directors serving on the board agree to that agree to that action in writing. So all means all. If you have an 11-person board, you have to get 11 written consents to the action. Email consent is fine, provided that we can clearly identify who the sender of the email is. So if you can pass something via unanimous written consent, that can be passed without having to occur in meeting. And again, if we step back and think about the idea of a duty of care and the role of the board, that makes sense, because if something is so uncontroversial that you can get 11 out of 11 people to agree to it, you can take final board action on that matter without needing to have a board meeting to kind of further discuss the issue. But those are your two options. You can either do something in a meeting, or you can do something via unanimous written consent. No hybrids. So you can't, bring something up during meeting, have a big discussion, and then vote via email afterwards. It's one or the other. Good question from the chat. Does the in-person meeting rule apply to board committees such as the finance committee? So that depends. There are sort of two flavors of committees. There are committees that are authorized to take final board action in an area of board responsibility. So the finance committee is actually a good example of that kind of committee. Some organizations have an executive committee that is sort of a subset of the board that's authorized to take final board action on sort of smaller matters that may pop up between regularly scheduled board meetings. So if you have board committees that are taking final board action, these same rules apply. Those actions should be taken in the context of a meeting or through a unanimous written consent. Some committees do not take final board action, and they're more advisory committees. They recommend actions to the full board. Those committees may or may not only be comprised of board members. Your rules can be a little bit looser for committees that only make recommendations and that do not take final board action in areas of board expertise. Or if you have a committee that does take final action, but it's really more of a staff or management level responsibility, like I'm thinking of, you might have a special events committee that plans your annual fundraiser, and it picks the caterer and the theme and buys flowers and stuff. Since that's not a board level responsibility, you can have non-board members on that committee, and B, you can be a little bit looser around the kinds of processes that you use in that sort of committee, because again, you're not taking final board action. Definitely look at your bylaws for rules around these board committees. And then here's just also another list of other meeting related issues that are often covered in nonprofit bylaws. When and where you hold your meetings, how much notice you require, how many directors make up a quorum. I want to dig into that last point, attendance requirements and thresholds. So as I sort of hinted at earlier, if you have poor meeting attendance, or if directors are missing a lot of meetings, that can be an operational challenge for your organization. It can be hard to meet quorum. It can also be a challenge in the context of this duty of care, because that kind of absentee director is going to have a more difficult time staying informed and making informed decisions. So something that you have the option of doing is to write in an attendance requirement in your bylaws, basically saying that if you miss a preset number of meetings in a year, you're automatically deemed to have resigned from the board. Those sorts of requirements are optional, but they can be useful for clarifying attendance requirements and then making it less awkward to remove a absentee director if they're not meeting those attendance requirements. So something from the chat, please clarify if a topic is mentioned during a meeting and a discussion is required, then such a vote can occur only in person or be done by way of email with more information later. So your options are, you can vote on that kind of topic in the meeting. I don't want to say in person because that's confusing, because if you're doing the meeting over Zoom or whatever, that counts as well. But you can vote on the topic in the meeting, or you can vote on the topic later by unanimous written consent, where 100% of the board agrees to the issue in writing. Or you can kick the issue down to your next meeting. So you bring it up in the meeting. After the meeting, you sort of circulate some materials, everyone develops their opinion, and then you have another meeting later on to make a final decision on the topic. But yes, your basic two options are always going to be unanimous written consent, or to tackle the issue during the current meeting or a future meeting. Okay, I'm going to get into some other areas of nonprofit management where, to satisfy your duty of care, the board should be extra present and should be thinking about a number of issues. One big one is financial governance. So overseeing and thinking about the financial health of your organization and the financial practices within your organization. As a board member, you're not responsible for day-to-day accounting, but you are still responsible for sort of the financial strategy setting when it comes to your nonprofit. So that means understanding the financial health of the financial condition of the organization and financial stability, sustainability. So making strategic decisions, read trends in fundraising, revenue, expenditures, and the health of your reserves, if you have reserves. What this means is that if your organization is losing money, if you're losing a critical funding source, if you're about to go underwater, you have to be engaged and present and responsible for rectifying that situation or for responding to that sort of financial situation. So again, you don't have to do the day-to-day accounting, but you do need to be ready to have these tough financial conversations within the organization. Another area that's really important here is fiscal controls and making sure that your expenditures are appropriate. So fiscal controls are policies like check signer policies or financial review policies, cash management policies. So enacting those sorts of policies within the organization, performing some back-end financial review of transactions that have already occurred, and for those large organizations, overseeing your audit process for those who do undergo an audit. All of this is to ensure that we're preventing fraud or mismanagement, and for sure ensuring that funds are spent only on approved and legal expenses. And then another issue that I want to bring up is your accounting practices and especially around restricted funds. So, ensure that accounting functions are properly delegated, who in your organization is doing the accounting, what kind of generally accepted accounting practices are they using. That's going to differ by the size and complexity of organization, but the board should be setting those norms and making sure that that finance and accounting is being performed effectively. And then for those firms who have restricted funds, so these are things like grant funds that can only be spent for a certain purpose, or endowment type funds where the donors have restricted the use of those funds for specific purposes, the board needs to be really thoughtful about how those funds are segregated and managed. You can, delegate that to staff to sort of figure out, but you as a board member need to be making sure that that management and segregation is occurring in your organization and that it's effective. Mismanaging restricted funds is a huge issue with nonprofits and something we need to make sure we're not committing in our organization. A question from the chat. We are considering a board of trustees. Are we also required to have a board of directors? You are required to have a board of directors or a body that performs the function of a board of directors. In some organizations, especially older organizations or organizations from other jurisdictions, they use the term trustee interchangeably with director on a board, and their board might be called the board of trustees, but functionally, they're probably going to be exactly the same as a board of directors. No matter what you call it, you need to have a body in your organization that is performing the functions of a board of directors as I'm describing them in the presentation today. I want to give you an example of sort of that financial management and accounting piece, again, ripped from the headlines. I think this is from January of this year when the Black Lives Matter nonprofit organization that sprung up in 2020 reported its first 990 for that fiscal year, and we got a better look into the financial practices and health of that organization. It was obviously wildly successful in raising $90 million in 1 year, and it continues to have about $42 million in assets. And the story coming out of like looking at Black Lives Matter's first 990 was a little bit mixed. One thing that was interesting was that in that year, it only had one voting board member. It was a Delaware nonprofit, and it was legal to have one board member in that state. But charity experts and folks like me will say that that is not a best practice, especially when you have a board managing, tens of millions of dollars. Imagine you have the equivalent of a cruise ship with no one at the helm, massive amounts of money, no structure, no accountability, no staff. Who even makes the decision on who writes the checks, right? So this is another really extreme example of an organization that is getting its legs under it, that's growing at an incredibly fast pace, and needs to think really, really deeply about the role of its board in financial management. Another aspect of this duty of care is risk management. And I like to introduce risk management. Folks might have heard me speak on this before as a three-part process for the board. So one is assessing your risks. So your board should either itself perform a risk assessment for the organization or delegate that function to someone else in the organization. But someone should be thinking, what would a really bad day look like at your organization? What are all the things that could go wrong, all the things you could be sued over, all the ways that people could be harmed within or be harmed by your organization? After we've assessed those risks, we need to mitigate as much as we can the risks that we've identified. So developing policies and procedures to minimize known risks, like safety policies, screening requirements, training requirements, et cetera, et cetera. And again, that process should be driven by the board, and the board should be ensuring that those mitigation steps are being taken when you can. And then for risks that we can't mitigate, or for risks that are inevitably going to happen no matter what we do, we need to start thinking about insurance. The board should engage with insurance brokers and providers to purchase adequate insurance to protect itself and the organization against those inevitable liabilities. This is not a risk management presentation. I'm not going to go super deep into how we do all these functions, but I just want to flag that as part of your duty of care to the organization, as part of your diligent service to the organization, you should really be thinking about these big risks and how we can mitigate and manage them. Another area that we need to think about is employment practices. So at least with respect to the executive director or the CEO, the board is the employer, the board is the boss. So as a member of the board of directors in this kind of indirect maybe way, you are also an employer of at least one person for those orgs that have a paid on-staff ED or CEO. And as such, you should be playing an active role in HR and employment compliance. As organizations get larger, as you get more funds, you may be lucky enough to be able to actually create an HR department, hire an HR director, blah, blah, blah. But for a lot of organizations in the growing process that are smaller, the board might find itself playing a more and more active role in HR and in employment practices. One thing that I want to flag for everyone is the issue of payroll withholding. Please make sure that your organization is withholding and transferring payroll taxes at the state and federal level. So like your FICA, your Medicaid. This is something that you should be withholding from paychecks and transferring to the government. Unpaid payroll tax liabilities can potentially trickle up to the board and to officers of the organization. So this is one of the few legal areas where you can have some personal liability if you allow your organization to go slack on its payroll tax responsibilities. So I just want to flag that for everyone. Most folks are using a payroll processing company and that's handling the stuff for them, but make sure you know what your organization is doing when it comes to payroll tax withholding. Another issue that we'll talk about later actually is this issue of executive compensation. The board is solely responsible for setting a reasonable compensation rate for your CEO or your ED. So we'll talk about that in a second. And then another key role for the board that's becoming more and more important is thinking about diversity, equity, inclusion, thinking about anti-harassment, and thinking about creating a culture of whistleblowing and reporting of HR related issues to make sure that these issues don't themselves become a huge risk area for the organization that can really affect the organization's health, its fundraising ability, its reputation, its connection to donors, et cetera, et cetera. This is an example ripped from the headlines. I think this was last year, of an organization like RAINN, which was and is still a very well-respected, large organization serving victims of sexual assault. Some stories in Business Insider around accusations of racism and sexism at the staff level, between staff and managers, caused a bit of a kerfuffle. They lost a bunch of top executives, and a lot of harm happened to the organization from this story and from these allegations. And so my question when I'm reading a story like this is, where was the board? What was the board doing to foster DEI, to discipline or investigate allegations of misconduct, and to create that culture of inclusion and also legal compliance and anti-harassment and anti-discrimination within their organizations in this sort of post-Me Too world that we're living in? I think that's becoming more and more of a core board responsibility and not just something that we can delegate to staff or other managers of the organization. We have a question from the chat going back to insurance. Does insurance provide protection to the board members, or should board members have their own insurance? That's a great question. I'll talk about it in a second a little bit more, but one insurance product that you should be thinking of, that all nonprofits should be thinking of and should probably have when they can afford it, is called Directors and Officers Liability Insurance, D&O insurance. This is an insurance policy that protects the board and can also be extended to protect your key employees in their personal capacity. So that is something that the organization is buying to protect individual board members from lawsuits that are accusing them of mismanagement or something else related to their service to the organization. Another great question: for nonprofits with volunteers as its only employment aspect, are there policies related to the situation? Definitely. You should be thinking about volunteers very similarly to the way that you think of employees. A lot of the liabilities around like payroll tax withholding and those like classic employer responsibilities don't exist. But when it comes to like risk management, for example, still a huge issue with your volunteers. To the same extent that you want to protect your employees against risks, you want to protect your volunteers against risks. And so volunteers are often in the conversation when we're talking about the board's role in A, managing risks, and then B, managing employment or employment-like relationships. For example, when it comes to training and screening, just like you want to make sure that your employees are properly screened and trained, you definitely want to make sure that your volunteers are properly screened and trained. So a lot of the conversation is the same. Let's talk about liability limitations. That question about insurance was great. There are layers of protection in DC that do protect you from liability as you're serving on a nonprofit board. In common law, we've had something called the business judgment rule, which means that if you're on a board and you're acting in good faith on an informed basis and in the honest belief that your action was in the organization's best interest, you're probably going to be protected from liability if some sort of lawsuit were to arise related to your board service, if all three of those prongs are met. So that should offer people some safety. That means that even if a lawsuit is filed and you end up in court and a judge is looking at the situation, they're probably going to say that, you know, you didn't, just because you made a bad decision or something went wrong doesn't mean that you're going to be personally liable. That's something called the business judgment rule. Now, it doesn't apply to criminal activity, fraud, or to willful misconduct. DC law also provides additional statutory protection to directors and other volunteers. So again, there's laws in the books that say you really can't be sued for your volunteer service to this organization unless you've received a financial benefit that you weren't entitled to, unless you intentionally inflicted harm or violated the law, or unless there was an unlawful distribution of the nonprofit's assets. So there's layers of protection here, but what I want to say is it's still a pain to be dragged into court in the first place. It's still costly to defend yourself up to the point where a judge does say, okay, you're good. These liability protections have kicked in and you don't need to be in this case anymore. So that is why that directors and officers liability insurance is so important. It can fund your legal defense costs up to the point of, you know, triggering these protections. It can fill in that gap. There's also something in DC and in a lot of other jurisdictions called indemnification. It basically means that your nonprofit is legally required to pay for the costs of defending your directors and officers in certain situations. So that's another reason that we want to have directors and officers liability insurance to fund those indemnification obligations. All right, great. That was the duty of care. That's the big one. We're going to talk about duty of loyalty very quickly, and then very quickly touch on the last two duties. So the duty of loyalty says that a board member is obligated to act in the organization's best interest and to not use their position to advance their personal interests or the interests of third parties like family members or other businesses or organizations that they're associated with. Okay, so in particular, a director must avoid conflicts of interest when approving transactions or making decisions. They must not usurp corporate authorities, and we'll talk about what that means, and they must maintain the confidentiality of non-public information. Day to day, that conflict of interest piece is the thing that we care about the most. What is a conflict of interest? A conflict of interest is when a board member has a direct or indirect financial interest in a transaction involving their nonprofit. They stand to potentially gain financially by approving a certain kind of transaction in a certain situation. The concern is that they may advocate for the approval of a transaction to line their own pockets instead of purely in the best interests of the organization. And this issue of the duty of loyalty interacts with IRS rules prohibiting private inurement and private benefit at nonprofits. Under the Internal Revenue Code, a rule says that no part of the net earnings of a corporation shall inure to the benefit of or be distributable to its members, trustees, officers, or other private persons. So this includes directors on your nonprofit board. Another concept that the IRS has is something called an excess benefit transaction. This is a transaction that provides a leader or insider of the nonprofit with an economic benefit that exceeds the value received by the nonprofit in return. So if a director overcharges the nonprofit, for example, for services that it's providing as a vendor, that's an excess benefit transaction. If a director approves excessive compensation for a family member who works at a nonprofit, they agree to let that person be paid way more than what the fair market value of those services that they provide are worth. That's an excess benefit transaction. It's a little technical, but this is an important concept because the IRS could potentially impose excise taxes on any insider who receives or approves excess benefits, as well as the managers and directors who approve the transaction. So if you're sitting on a board and you end up approving a transaction or a compensation deal that over benefits another board member or an officer or someone else related to the organization, there could potentially be some personal liability there for approving that kind of excess benefit transaction. So it's important that you understand that this is a rule. The big takeaway is that board members must ensure that insiders, so other directors, officers, executive staff, do not receive favorable treatment or excess financial compensation from the nonprofit. This is a diagram that I make that sketches out what a conflict of interest situation can look like. So we have an individual at the bottom. This is you. You're a director of the board. You serve as a director on the nonprofit. That's the arrow going up and to the right. At the same time, you have a relationship with another entity. That's the arrow going up and to the left. Maybe you own it or you control it. Maybe you are paid by it. Maybe you're a director of that other entity at the same time, et cetera, et cetera. And then the conflict of interest situation is when your nonprofit is contemplating a potential transaction with that second entity that you also have a relationship with. Okay, so this is the kind of core template situation that we want to think of. I'm going to complicate it a little bit more and say that if you have a family member who owns or controls that second entity, the same analysis applies. Okay, so it applies whether you directly own the other entity or if you're related to someone who owns or controls that entity. This is when the board needs to be extra careful around approving that kind of transaction. It's not per se illegal, but a red flag goes up, and we want to make sure that if we do approve that sort of transaction between our nonprofit and a company that our directors own or control, that it's still within the best interests of the organization. Let me give you kind of an example of when this can go wrong. There's a very famous nonprofit school in Pennsylvania, the Hershey School. In 2010, there was a big scandal where the board approved the purchase of a $12 million failing golf course that it said that it needed to buy as buffer land to protect its students at the school. One big issue is that this failing golf course, one of the investors of the golf course was on the board. And when the nonprofit purchased the golf course and made improvements to the golf course, that indirectly benefited the director who invested in the golf course. You know, it made up for some of the money that he was losing on the golf course. So that is a classic conflict of interest transaction. That director should not have been approving the purchase of the golf course. And the board should have been really careful around that decision to approve the golf course. I want to direct your attention to the third paragraph, though, which is also interesting. In 2011, a board member also sued the organization, claiming that they violated their fiduciary duties by purchasing the golf course at all. The board member said that they didn't perform a financial analysis to support paying $12 million for the golf course. So that's actually a different duty. That's the duty of care. Okay, that allegation is saying that the board was not careful enough, didn't collect enough information, didn't make a reasonable decision to purchase the golf course. That's a duty of care violation. The duty of loyalty violation, which is the section that we're currently in, is that issue where someone sitting on the board approved the purchase of a golf course that he had a personal investment in. All right, so hopefully that sort of fleshes out some of these dynamics. How do we manage conflicts of interest? If we're in a situation where the nonprofit is contemplating a transaction with an entity that their directors have a stake in, first step is to disclose potential conflicts of interest and remove the conflicted directors. You should have a policy and a practice at your organization where directors abstain from participating in discussion and voting in any situation where a conflict exists or potentially exists. Directors should affirmatively disclose whenever there's a potential conflict. Also, every year you should be doing something called conflict of interest disclosure forms, where directors are telling the organization every other entity that they have a potential stake in, and you have kind of a database of these other organizations so that if you're contemplating a transaction with someone, you can run that against your database of potentially conflicted organizations and identify that, you know, so-and-so director should not be involved in this discussion. So once we've removed the conflicted directors, the remaining members of the board can debate and analyze whether moving forward with the transaction is still in the best interest of the organization. So let's say our nonprofit needs to hire a contractor to do a lot of printing and publishing. And it just so happens that one of our directors also owns a printing and publishing company. And they offer to sign a contract with us, giving us a really, really good deal on a printing and publishing project. Okay, so in that situation, we're going to say, thank you for the proposal. We're going to remove you from the discussion, that director that owns the printing and publishing company. And then the remainder of the board is going to compare that proposed deal with the potentially conflicted vendor against other deals that they find at the marketplace. And if at the end of the day, they do decide that it's still the best deal for the organization, they've considered the alternatives, they can proceed to approve the conflict of interest transaction. To help guide you through this process, everyone should have a conflict of interest policy that provides some guardrails and some standard procedures for handling this kind of situation. And if things get complicated, please consult with legal counsel or volunteer attorneys to help you manage this process. It's so important to avoid those excess benefit transactions that we have a good COI management process. Oh, and a note that you should be taking detailed notes regarding how you manage these conflicts of interest, because if you are ever to be, audited or investigated by the IRS, you want to show that you've been doing it right. Yes, we did remove the conflicted directors by the room. Yes, we did compare alternative proposals, and we made a reasoned decision that sticking with the potentially conflicted transaction was still the best deal for our organization. Okay. A special kind of sub issue with conflict of interest are CEO compensation. Setting the compensation of your top executives is a unique function of the board. The IRS is extremely concerned when directors overcompensate themselves or their peers or other chief executives, because that's been a classic way to sort of sneakily perform an excess benefit transaction. It's to hire someone, their salary should be $100,000. You pay them $300,000. That's a classic sneaky way of indirectly giving that person $200,000 for free. So the IRS knows this, and so executive compensation is a big priority for the agency. And so there's a whole separate process around how you can safely and reasonably establish how much you pay your CEO and other top executives without getting in trouble with the IRS. We call it the safe harbor procedure. And basically, if we follow it, it's a 4-step process. Basically, you create like a compensation committee, or you take the whole board and you engage in a compensation process. You eliminate everyone with a conflict of interest. You use comparator data. So you figure out how similar organizations, how much they're paying their executives, and you use that to set what a reasonable rate is for your executive, and then you document the process. So we have another law help webinar that walks through this. I'm not going to spend a lot of time on it, but CEO compensation is a unique duty of the board. It's something you have to pay a lot of attention to. Let's talk about compensating the directors themselves. Directors are essentially never compensated, especially in small nonprofits, for board service. You can reimburse them for out-of-pocket expenses, but folks are generally not paid just to serve on the board. It's traditionally a volunteer function. If you are paying your directors, it creates a lot of thorny, borderline unmanageable conflict of interest questions. And it's also so unusual that it just creates a huge red flag for the IRS and for funders, donors, government contractors, etc. So it's not a practice that we see a lot in our sector. Now, to note, you could also pay your directors for labor that they perform as a contractor or as a staff person, but when we're analyzing that kind of situation, we're going to run it through our conflict of interest analysis that we talked about a few slides ago. A quick note that loans from the organization to directors are illegal in DC. Okay, that's the core of it. I'm going to touch really quickly. There's something called the usurpation of corporate opportunity doctrine. It basically says that when you, as a board member, are living your nonprofit life and you find a good business opportunity that you think the nonprofit might be interested in, you should present it to the organization and give the organization kind of a bite at the apple as part of your duty of loyalty. You should be pushing those opportunities along. Even if you have a personal interest in the opportunity, your organization gets a first bite at the apple. All right, so I don't think it comes up that often, but If you see a business opportunity that the organization might be interested in, disclose that to the org, let them get that first bite. And then the last component of the duty of loyalty is maintaining the confidentiality of information. Don't disclose information about the organization that you learn in the course of serving as a director unless there's already been a public disclosure, unless it's already in the public record, it's a matter of public knowledge, or you are required by law to disclose the information. Outside of those exceptions, hold very tightly the information that you learn about the organization. That is a part of your duty of loyalty to the org. We are at time. I'm going to go a little bit over just to touch on the final two duties that are very bare bones. For folks who have to log off now, of course, this will be recorded, so you can catch up in a second. But let's talk about the duty of obedience for 30 seconds. It's a really simple duty. It just says that your board members must follow the organization's purposes and goals as set out in your bylaws, your articles, your mission statement. You must obey policies and procedures adopted by the board. You must also obey federal, state, and local laws and regulations and ensure that the organization does as well. Kind of a no-brainer. I don't know how you would satisfy your duty of care without simultaneously making sure that your organization is following the law. Okay, but kind of traditionally, this is broken out as a third fiduciary duty that we think about separately. I do want to make a note that the IRS agrees that good written down governance policies and practices, especially a conflict of interest policy, a whistleblower policy, and a document retention policy, support legal compliance at the organizational level. So while we're talking about this duty of obedience, I just want to plug for folks that we have template governance policies available on Law Help, and that part of your service to the board is making sure that those policies are implemented at your organization. Another side issue while we're talking about the duty of obedience is to touch on record keeping very briefly. I should note that board and board committee meeting minutes should be prepared within 60 days of the next meeting. That's a IRS rule and kept permanently. The IRS also requires that you keep certain records and that you make them available for the public. Specifically, these are your Form 1023 and also your Form 990s from the past 3 years. Failure to make these records available to the public can result in a penalty tax. There's actually some interesting nuances around how you do this. So again, we have some Law Help resources on public disclosure and nonprofit transparency that you can look at. But for now, as a board member, please just make sure that someone in your organization has thought about, making your 990s and your 1023 available to the public. If you don't have these documents, there's a form you can file with the IRS to get a copy of them. And then finally, the DC Nonprofit Code has some record keeping requirements of what you need to be keeping at your principal office. So like you should have your articles, your bylaws there, your minutes, et cetera, et cetera. So there's some local requirements as well. No legal penalty for failing to comply with these DC requirements, but directors and members do have a right to inspect these records. Okay, and the last duty I'll touch on is a duty that's not recognized in every jurisdiction. It's another kind of no-brainer, but excuse me, it says it's the duty to inform, and it says that directors must inform fellow board members of any wrongdoing or material information related to wrongdoing or legal violations that they discover in the course of their service. So this is a see something, say something kind of rule. If you do discover misconduct or information relating to misconduct, report it up to superior officers or to the whole board or to relevant officers within the board. All right, something I think a lot of people grasp instinctually, so not too complicated, but that's a fourth duty that you'll see in the literature and that you'll see in some of the statutes. That's the presentation. Thank you all for sticking by. Sorry we went a little bit over. If you have any questions related to what we've talked about today, my email address is jqu@dcbar.org. Again, that's jqu@dcbar.org. You can hit me up. I see questions in the chat that we're not going to get a chance to get to everything today. So please, let's continue the conversation afterwards. Since we're already over time and folks can drop off whenever they want, let me do a quick scan and see if there are any questions that make sense for us to close out on. So give me 2 seconds. Someone had a question about unanimous written consents. What if someone abstains from a unanimous written consent vote Yeah, that means that you do not have unanimous written consent. If you're going to pass a board action via unanimous written consent, you have to have an affirmative vote from all board members, no abstentions. A question, how do you decide what decisions require board approval? That's a really interesting and a kind of complicated, delicate question, because it really depends on the balance in your organization between the board of directors and how much staff you have. If you have a really robust staff that's handling a lot of core management responsibilities, that leaves fewer and fewer day-to-day decisions for the board to make. And as we've said, the board can kind of sit back and take on a more strategic oversight and governance related role. And so its role is going to be really, really high level stuff, financial policies, approving governance policies, budgeting is still going to be within your realm of expertise, strategic planning, hiring the CEO. You know, there are sort of these classic areas that are always going to be board responsibilities. But, you know, other high-level decisions that impact your organization financially, so big purchases, real estate deals, you know, things like that, that's going to be a board responsibility. And then on the programmatic side, decisions that really affect the mission and the operations of the organization. If you're going to create a big new program line, if you're going to get involved in a new issue area that you haven't been involved before, those high-level strategic decisions are always going to be within the realm of the board. So that's what's always going to be within the realm of the board. But then, you know, those management decisions, that's really going to just depend on how much staff you have on hand to handle those other things day to day. A question of whether the slides are available. Yes, they're available here for folks listening live. And then for folks who cannot attend the live session, they're going to be posted in the same webpage where we post a link to the webinar recording. All right, so we're going to end off there. Thank you again for joining us. It was a pleasure meeting everyone. We have a great archive of other board basics webinars on our Law Help website. Again, that's lawhelp.org/DC/NPSB. If you want a webinar on how to take minutes, if you want a webinar on how to call a board meeting, if you want one on navigating conflicts of interest, all the nuts and bolts of running a nonprofit board, we archive those resources there. So to close out, I'll just encourage everyone to visit that website and to continue learning. But thank you today for joining us for this presentation. All right. Bye, everyone.